be present and take his plea. Yes. So, unfortunately, on Monday, he did not honor the invitation, neither the undertaking given by counsel given effect to. It was never given effect to. Then your lordship graciously and reluctantly adjourned it today so that he can take his plea. My lord, I think what the defense is doing is to overstretch the administrative of criminal justice system in this country. My lord, and I have my reason. For the first time in my years of practice, I saw yesterday that 3 courts were sitting simultaneously over a matter in relation to these accused persons. The Code of Conduct was here. There's an application to stay. The Code of Conduct had to bend backward and ruled, I cannot stay this proceedings. Come and take your case. They went to Federal High Court. The same application, injunction to restrain the tribunal from acting. The High Court said, no, go and face your matter there. Come next week for the application. If you want to argue the application, put them on notice. They proceeded to Court of Appeal. 3 courts. And the Court of Appeal said, no, I don't want to interfere in what is going on. Go and put them on notice and come on Wednesday next week. So, my lord, having exhausted and overstretched our administration of criminal justice system in Nigeria, they still came back this morning. They are not prepared. They will not go to the witness box. They will not go to the accused box. My lord, the court should not be taken for granted. The court meant business. They are the one that made this law at this 8th assembly. The 8th assembly came and said, no, we have to change from our way of life. Yes. We have to be serious. 7th assembly. We have to change our criminal justice system. We have to stop preliminary objection. And they say, don't file preliminary objection again. If it is filed, it will not be taken. He has to take his plea. Section 296, 2 says so. Don't take preliminary objection. The accused person must take his plea. 396, take his plea first. If you have any objection, you can then raise it. In fact, that objection will be delayed on the ruling on it. Then, in their own wisdoms, they will need to change as a nation. So, my lord, the judiciary saved the nation yesterday. Judiciary saved this country yesterday. My lord, assuming your lordship made another yesterday, and it conflict with the order of Federal High Court, or the order of Court of Appeal conflict with your lordship's order, that is the kind of gangmare that these people want us to be yesterday. But the judiciary saved us. So, my lord, what I'm saying is this. The business of today, the business of the court today is for the accused to take his plea. Not any preliminary objection. Not any preliminary objection. And he should go to the boss and take his plea. That is the law. That is the position of the law. All the authorities that my learned friend is relying on are pre-made decision of court that has no statutory backing. So, my lord, the statutes has changed those lines of authority. So, my lord, I urge your lordships to order the accused person, go to the box, take your plea. If the counsel has anything to say thereafter, you can do so. That is my submission, my lord.
JB, please, let me talk. Please, let's try to, I will expect you, JB, as a former president, to lead us. You should be part of the solutions to this problem. I'm speaking to you honestly.
I'm trying to be a solution on the path of justice. I'm sorry, sir. I've heard you. But the point is that it doesn't take us five minutes to express ourselves. What appeared to gag us before we speak is with respect. What I have fundamental issues. It didn't take me 5 minutes to point it out. My learned friend seems to be under the misconception that this is a criminal trial. Your lordships know. Your lordships know because you are very familiar with paragraph 15 and 18 of the Constitution. And it clearly says there, because this is very fundamental, so that my brother, Rotimi Jacobs, will not think that the Administration of Criminal Justice Act applies. I'm just trying to refer you to paragraph 15. I think we need to look at it, and so that we know what we are doing. If you rule that it is a criminal trial, we will know what to do. But let us at least point it out. Maybe we are misconceived. May I refer you, sir, to paragraph 18. Please, you've spoken now. You don't want the truth to come out. Let me refer please sit down, I'm on my feet.
Counsel.
Yes, sir.
Please.
I'm trying to refer you to what will guide the tribunal. It won't take me 2 minutes. And if I mislead the tribunal, then any sanction can be sent on me. But why shouldn't I be heard?
2 minutes.
Yes, 2 minutes. I will do so, sir. 2 minutes. 18. It says, sir, paragraph 18.1 of the fifth schedule, 18.1, where the Code of Conduct Tribunal finds a public officer guilty of contravention of any of the provisions of the code, it shall impose on that officer any of the punishments specified in subparagraph 2 of this paragraph, and any other punishment that may be prescribed by the National Assembly. And it refers to the punishments to include vacation of office, disqualification, and seizure and forfeiture. Then the next one says, the sanctions mentioned in subparagraph 2 hereof shall be without prejudice to the penalties that may be imposed by any other law where the conduct is also a criminal offense. So he's saying that where it is a criminal offense, it is another court that will do it, and that's what 6 says. It says, nothing in this paragraph shall prejudice the prosecution of a public officer punished under this paragraph, or preclude such officer from being prosecuted or punished for an offense in a court of law. The meaning of this is that you are not a court to try criminal cases. The punishments you are limited to is vacation of office, seizure, and forfeiture.
You are misconceiving the provisions of that particular
rules are that have misconceived it.
Matters before this tribunal is criminal in nature.
No, sir, it's not. I've said here that I've referred you to the Constitution. If you take me, overrule me, it will be on record. This is the first port of call.
The fact before the court at this time is for the accused to take his plea.
We are saying, sir, with profound respect.
We will listen to you after the accused person has taken his plea.
Not even an accused person, he's a defendant.
The defendant, let it be the defendant, but whatever it is, he should take his plea first before any other application is moved. That is the order of the tribunal.
Rules, sir, in writing. Then we know when we are going to get it. I referred you to paragraphs 18, 1, and 3 to say that this is not a court of criminal jurisdiction. And therefore, the Administration of Criminal Justice Act does not apply.
Okay.
Sorry, didn't you read this yesterday? He's careful. Very
please, keep quiet. Let us respect this court, please. Thank you very much.
And And the provisions of the Administration of Criminal Justice Act does not apply.
It does not apply because it is not a criminal court known under Section